a lot of clients come to me that fall into this situation where they're very close to falling in a deep hole. They're living hand to mouth, and any little disruption in their life would basically set them back to where it's like falling off a deep cliff, and they'll never get back to that level. And without me, they would fall off that cliff. If I can step in at that point, take them down a different course, whether it be getting involved in the case very early and getting them medical treatment that they otherwise couldn't receive, or basically having an insurance company change the position in a case very early and accept liability, where if an attorney hadn't gotten involved, they would have denied liability, and that person would never have seen recovery and would have potentially lost their job, incurred huge amount of medical expenses they never could pay because they don't have health insurance. I started out, I was actually working for insurance companies. My first job out of law school was as an insurance defense lawyer. And in that role, I got to first-hand knowledge of how insurance companies treat people, or how big businesses treat people. And I, quite honestly, didn't feel comfortable with that. And I didn't always agree with the position that, that my client at the time wanted me to pursue. I didn't agree with the way they were handling the case. I didn't think they were treating someone fairly. I didn't think they were doing what they were supposed to do. And so I decided I'm not going to do this anymore. I'd rather represent people. I'd rather each client be an individual, so I can represent that individual the way I see fit, as opposed to the way someone tells me to represent them. I think a trial lawyer is someone that I guess fights for someone that can't fight for themselves. Most of the clients that come to me don't have the education level, don't have the knowledge, don't understand how to rectify a situation that they're confronted with. And they come to me as someone that has that knowledge, has experience, and can understand how to best represent them and best fight for their cause. I've had a couple of occasions where a client has come to me and I've had to explain to them, well, this is what you're entitled to recover under the law. And they say, well, I don't understand. Why am I limited to this? And I said, well, you remember that legislation that passed a few years ago where, that was what you were voting on. And whether you voted for it or not, that's what the people of this state passed as the law, and that's what we have at this point. Coming to me can only get you so much. You need to go talk to your legislature, because that's really, they're the people that make the laws. Attorneys only apply them to the situation and fight. The laws are all we have to fight with, and we don't make the laws, we just apply them. In North Carolina, they have what's called contributory negligence, which contributory negligence, they're one of the only 3 states in the country, I believe, in the District of Columbia that have contributory negligence. And what that means is if the victim or the injured party is 1% at fault in causing their injury, they're completely barred from recovering in the case. And as you can imagine, insurance companies and other big businesses are very crafty in coming up with theories on how you just slightly contributed to causing an injury, and therefore we don't owe you anything. Where most states have a comparative negligence system, where part of the jury's function in the case is decide what percentage the defendant's at fault versus what percentage the plaintiff might be at fault, and award damages based on that percentage. But in states like North Carolina, if they can come up with any reason to say you're 1% at fault, then you wouldn't be able to recover anything. There's been a lot of news, a lot of discussion in the news about how these attorneys make these outrageous fees on these cases. They don't put a lot of work and time into the case, and they take these huge percentages of the recovery. And that is true. That there are certain cases where that does occur. At the same time, you don't see the cases reported on where attorneys do take a case that has merit. The damages and the recovery might not be that great, but there's merit to the case, and they take the case, put in quite a bit of time fighting for the client, and their recovery at the end of the day is a small recovery, a modest recovery, yet the time and effort put into the case is not represented by that amount. So that's just part of the contingency fee system that allows people to have access to justice that otherwise they would not have. If we did not have the contingency fee system, I speculate 80% of my clients would not have representation, because they just could not afford to hire an attorney, because they have limited means, they don't have a lot of money, they don't have the means available to go out and pay an attorney a retainer to take their case on the front end. They have to rely on the attorney getting paid in the end, because otherwise they couldn't afford to hire an attorney. There are a lot of cases that I call them pro bono cases. They're not pro bono in the sense that I handle them at no charge, but when I accept the case at the beginning, I know that the amount of work I'm putting into the case is not going to correlate with my final recovery in the case. It's hard to sit there across the conference table from someone and see the fear in their eyes, see the desperation in their eyes, and tell them, I can't take your case because the fee's not going to be large enough to justify me taking the case. Sometimes I'll take a case where I just say, you know what, this person needs my help. They may not get this help from somebody else. I'm going to help this person. My name is Michael Chandler. My firm is Hull & Chandler, and we're located in Charlotte, North Carolina. I practice pretty much exclusively personal injury law, mainly involving motor vehicle accidents and other similar type injuries.